to the chairman. I will be as brief as possible, noting the little time that I have, and I hope that I'll be as useful to the bench as my colleague Mr. Mahat has been. Now, I will straight away start with the questions that were put to the first and second respondent by His Honorable Justice Ouko. And the first question was to do with the question of unutilized ballots and how they are accounted for. This is the way unutilized ballots are treated. At Regulation 69, which provides for the voting procedure, that is the Regulation 69 of the Election General Regulations, it provides that a voter will be issued with ballot papers for all elections in a multiple election, that is at Regulation 69.2. At 69.2a, he is expected to cast his votes in respect of all the elections. 69.3 makes it an offense for a person to knowingly fail to place his or her ballot paper issued to him inside a ballot box. But at Regulation 77e, an unmarked ballot is treated as rejected and is void and shall not be counted for purposes of declaring a result at the polling station. At Regulation 78.3, the presiding officer then is put under an obligation to record in Form 41 the head of rejection for each ballot, and for our purposes, Subregulation 3D then addresses the question of unmarked ballots. Regulation 81B then provides that rejected ballots, such as the unmarked ballots, are sealed in a tamper-proof envelope and placed in the ballot box. That is how they are accounted for, Honorable Justice of the Supreme Court. The second question that I shall deal with, and this again it was posed by His Honorable Justice Mr. Ouko, was whether the appointment of the chairperson as returning officer was as an agent of the Commission or as a national returning officer in his capacity as chairman. This is how I would wish to address this question. It is a direct one, and the answer lies in the Constitution. Article 138.10 places an obligation upon the chairperson of the Commission to declare the result. So the gazettement was not for purposes of Article 138.3c, but specifically for Article 138.10 to fulfill that role, to take up that responsibility, to account for that result that follows a presidential election. That is the specific purpose for that gazettement. But while I'm on this question, I would also want to pose another question. Would it then mean that if the gazette notice was to fall away, would it then mean that the chairperson of the Commission under Article 138.10 would not be in a position and suffer lack of constitutional authority to declare that result? My answer is no. In other words, the gazette notice is purposely to tell Kenyans that the Constitution has rested these obligations upon this office to declare that result. Beyond that, it is superfluous. And I urge Madam Chief Justice and Honorable Justices of the Supreme Court that that particular gazettement should not be read to mean that the chairperson had gone rogue, that the chairperson had taken upon himself and arrogated unto himself a power that he did not have. It is the Constitution speaking. It is in fulfillment of a constitutional expectation and obligation under Article 138.10. If you allow me, my colleague Mr. Mahat Somani will address the other punctuated questions that don't feature in my presentation. I will address the questions posed by His Honorable Justice Mr. Lenola. And this question is to do with the understanding of the state of the law as far as Section 83 of the Elections Act is concerned. And this is our submission, that the law is in a state of flux. Why do I say this? In 2017, the statutory provision that then existed suffered an amendment through Election Law Amendment Act number 34 of 2017, effectively repealing the 2017 provision. Now, the new amendment similarly suffered terminal fate before the High Court in the Katiba Institute case. Therefore, one would be tempted to argue that as far as Section 83 is concerned, we have no law. But in my humble opinion, I would be more kind to the state of the law as it exists. It's in flux. Why do I say this? This court had had opportunity to address questions of what happens to a repealed statute when the replacing statute itself suffers the same fate, in the BBI case. And there was differing opinion, understandably so, because it's not a question that can be easily wrested. In my earlier days, if you ask me, I would say there's no power to animate the previous provision of law. It rested where it did at the point of being repealed or being declared unconstitutional. However, the Constitution provides a mechanism by which we can determine the validity or invalidity of an election beyond Section 83. That safety net is to be found in Articles 81, as read together with Article 86, and specifically for purposes of a presidential election, we must read it together with Article 138(3)(c), which then provides the qualitative test, the process that we then use to arrive at that result to be declared under Article 138(10). So that at Articles 138(3)(c), there is a process of verification and tallying of those results that then come from the polling station and from the constituency tallying centers. All right? Under Article 81, we are then to observe certain principles of the electoral system, failing which then an election can be rendered invalid. Article 86 addresses itself to the voting method and sets out principles that then must be observed in operationalizing that voting method. That is a qualitative test. The quantitative test then is found again under Article 81, or rather 86, sorry, 2, where counting is involved of votes cast, and Article 138(4), which then sets the criteria for declaration under Article 138(10). So then it is my humble submission, even as the state of the law remains in flux, there is a standard by which we can determine the validity or invalidity of an election, and that is my humble submission on that point. The second question, Madam Chief Justice and honorable members of the Supreme Court, directed at the first and second respondent by His Honorable Justice Lenaola, was why didn't the chairperson wait until the next day and try to reach consensus and address the 27 constituencies? It is important to point out at this juncture that the 27 constituencies had been tallied and had undergone the verification process, and were ready for announcement by Professor Goulier. My lords and my ladies, I refer the Honorable Court to paragraph 35 of the affidavit of Professor Goulier, filed in the main petition. And as to the circumstances why the chairperson opted to declare the results on the very day that he did, the explanation is to be found in paragraphs 86 and 111 of his affidavit. But if I may summarize, he made considerations concerning security of his staff, who at that particular point in time were suffering arrests, abductions, and injuries to officials, including commissioners. In his mind, it was prudent to conclude the exercise since Article 138 3C had been fully satisfied. And there was a legitimate expectation that the results were to be declared on the 15th of August, as had been announced on that very morning. I'll quickly address the questions that were raised by Honorable Lady Justice Njoki. The term commission used in multiple senses. How do we know which sense is applied when? My quick response: it is a question of the context in which the term commission is used. Section 2.1 of the IBC Act defines the commission to be the IEBC. Section 11A then breaks it down further to provide that there is that policy organ which is then constituted of the commissioners, including the chairperson, which then tasks itself with oversight, strategy, and policy, and the secretariat that then deals with administrative issues on a day-to-day and executing matters of policy that then the commission, or rather the membership of the policy organ, directed. Therefore, in my humble submission, it's a question of context on how the term is used. What are the checks for this all-powerful chair? For instance, if he was to announce the wrong results or be incapacitated in such a manner that then he could not declare the result. The checks are to be found within the constitutional and statutory framework. Follows. Article 138 then speaks to the checks. Article 138 3C speaks to a verification and tallying process that then engages the commission, the body corporate, so that there is no room for the chair to act as a lone ranger. And while I'm at this point, it is important to point out that in this particular case, Article 138, 3C was fully satisfied. My lady, my lords, a narrative has been created that certain commissioners were given roles akin to domestic services. Nothing can be further from the truth. We all saw it. We all saw the commissioners interacting with the results, interacting with the verification and tallying process. We all saw them announcing these results. We cannot unsee what we saw. But then, just to lay emphasis on this, I would wish to quickly refer the Honorable Court to paragraphs 40 of the Chairperson's affidavit, Wafula Chebukati, paragraphs 8 and 9 of the affidavits of Professor Abdi Gulier, and paragraph 7 of Boya Molu, which speak to the truth of this issue. Quickly, my lords, on the last question, on the issue of agents and their roles. Agents play an important role in the electoral process. It's up to the parties and candidates to appoint them. But for purposes of Regulation 79(7) and 62(3), the absence of agents does not invalidate proceedings at the polling station. That would be the end of my presentation. Unless the court has any question for me, I would ask to resume my seat. Thank you, and invite Mr. Ma.